The next exposure we identified is cyber liability. And before I want to get into that, I want to talk about CMR 17. For those of you who do not know what CMR 17 is, it is a Massachusetts law that safeguards against identity fraud. I will read briefly a section of the law for better clarity. And I quote, "This regulation establishes minimum standards to be met in connection with the safeguarding of personal information contained in both paper and electronic records. The objectives of this regulation are to ensure the security and confidentiality of customer information in a manner fully consistent with industry standards." And for more information on CMR 17, you can visit mass.gov. But a key point I want to point out here is the fine you would face if you are breached. And the fine is upwards of $5,000, and that is per file, per breach. So it can get pretty costly for a business who is breached. But for a business who is breached, as we discussed earlier on direct costs and indirect costs associated with the risk, the cost of failing to protect yourself from a breach can result in direct costs such as lawyer fees and notification costs. The notification costs can be described as providing a credit monitoring service for all breached clients and clients that may have been breached. Indirect costs from a cyber breach can result in a negative industry reputation, which was referred to earlier on in the Lloyd's of London survey from the top CEOs worldwide, that a high concern of theirs is their reputation. The final exposure for cyber also contains copy machines, shredders, trash, and laptops. What are you doing to protect yourself from the sensitive information in all four of these? The biggest one we see is the laptop. An employee may take a laptop on a business trip. We've seen them forget it in the airports, hotel, and the cab. So the bottom line is, what are you doing to protect yourself from sensitive information in your copy machines, shredders, trash, and laptop?
Workers' compensation is a very simple policy. Payroll times rate equals premium. However, it could be your largest direct insurance cost. By learning more about this exposure, by planning and training, we may be able to lower the total cost of risk. Has your risk advisor made you aware of a potential 19.3% increase in rates and a doubling of the ARAP this September 2012? Would having this knowledge allow you to plan more efficiently and effectively? When you reviewed the complex algebraic formula within the experience modification calculation last year, did you find any errors? Even though computers are involved, we're finding errors, and we're also finding errors with the information used to calculate the mod. Paul?
When a workers' compensation claim occurs, the insurance company adjuster sets up an estimate. This is also called a reserve. And as the claim progresses, the reserve eventually becomes a paid loss. But workers' compensation claims frequently take several months, if not years, to settle. It's important that the reserves be reviewed to be sure that they're reasonable. It's important that the reserve be reviewed in the workers' comp modification calculation, because we frequently found situations where the reserve will be entered into the mod for a claim that has been settled. And if it's been settled for less, it's obviously incorrect, and you would want it corrected. In Massachusetts, we have a rule called the aggregate and equity rule, and it is basically said that you have 30 days after the modification is effective to have the modification corrected. You can do this by talking to the Bureau. There's a form that has to be completed. But it's obviously important that it be done, and that it be done quickly. The classification is also an item that is very important in determining workers' compensation premium because of the huge difference in rate. For example, the clerical rate is 9 cents per 100 of payroll. The rate for a foundry worker in Massachusetts is $8.46. I would suggest you become familiar with the various classes and make the class determination yourself. Do not rely on the insurance company auditor. It is sometimes difficult to determine the correct classification for an employee, for example, that does 2 jobs. The manual requires that the higher rate be used regardless. Some auditors, however, will only use the higher rate if it is a regular and frequent part of the employee's job. Perhaps the best advice I've received was from the former president of the Workers' Compensation Bureau of Mass. He said, in workers' compensation classification, you must use a lot of common sense.
Occupational medical providers are a new entrant into the marketplace that provides a valuable service for workers returning from injuries. Light work programs simply do not provide occupational therapy sometimes needed by returning workers. Since they are lower cost than a hospital or a physical therapist, planning with occupational medical providers before an accident makes fiscal sense. Most employees are exposed to their company's discrimination policy the first day on the job when they're asked to sign their employee handbook with the policy buried within the handbook. Constant training is the only way to institute a discrimination policy that works and to show an underwriter you are serious about discrimination within the workplace. Communicating this training to the underwriters results in lower costs. Insurance carriers have proclaimed that employment practices liability is the slip and fall of the 21st century. The claims are on the rise in every state and in every industry. When firms have employees out of their control at other locations, we strongly urge third-party coverage. This coverage protects your firm against any discrimination caused by your employees at other firms. Within most of these policies, there is a hotline to a law firm on retainer for the insurance company. The hotline allows the firm to develop a plan with a lawyer before firing any employee. This next slide is for your managers. We find that when confronted with a discrimination accusation, most managers do not know what to say or do. If your manager conveys this to the victim, it is a great starting point from which your lawyer can begin any defense for you. Let's review. SPUR is simple. It's an acronym. We take these allegations seriously. We have a policy against inappropriate behavior or actions. We will investigate, and there will be no retaliation. Retaliation is fast becoming the #1 way people claim against employers. David?
Unlike general liability, which responds to bodily injury and property damage claims, errors and omissions, also known as professional liability, responds to financial harm. The errors and omissions programs provide coverage for temporary or permanent placement of individuals at clients' facilities. An example would be the placement of an unqualified or underqualified individual, which results in your client having downtime as a replacement is secured. The downtime loss could also include the costs associated with locating a qualified individual and the possible loss of their business as a result. A true example provided by Access Pro is negligent placement. An agency's client discharged a temporary employee because he was using the internet connection at work to down sexually explicit material. The disgruntled employee then deleted work-related computer files. The second component of the errors and omissions is the errors made by the placed individuals. An example being a nurse practitioner or phlebotomist malpractice error. Another is a bookkeeper's error causing the client to shut down business and dedicate both time and resources to correct the problem. There is also the exposure of an individual originally hired as a bookkeeper is transferred to a heavy machinery operating position of which they are not qualified. Although many firms purchase the coverage, it is important to note that the coverage and exclusions are different, not only to understand the coverage provided, but the difference in policy forms. Policies can be written on either a claims-made or occurrence policy form, whereas the occurrence forms are most preferred, depending on your business, claim industry, and industry served. The claims-made form may be the only viable option. Remember, not all forms are equal on what they provide for coverage. Whereas most property and general liability policies have standard forms providing coverage, errors and omissions policies can differ greatly between insurance companies.
We've indicated throughout the presentation that the correct way to do a risk assessment of your firm is through asking a series of questions to identify your exposures. We don't have the luxury of doing this with all of you today, but we've identified some exposures that are prevalent within your industry, and we hope you found it helpful. Again, when your exposures are identified, you can manage those exposures by developing a plan. And managing risk through planning and training will make your business more attractive to the insurance marketplace. In wrapping up, I want to thank you for attending. I hope you found this helpful. And again, as I said, the link is on the last page here. And for all your questions, you can be directed there. You can type in the question, and we will have all the questions and answers you have, the presentation and the take-home worksheets. Again, I just want to thank you, and I pass it to Gene. Is Gene on the line? All right, well, we'll see all of you at the golf tournament. Thanks a lot.